Back at it, Dennis, you might not have gotten it. I got it. All right, you guys have the floor.
Yeah, this is similar to the law we proposed a couple of meetings ago, this committee as well as the Rules Committee. The difference is that this particular version has been narrowed to apply only to misdemeanor narcotics offenses, to controlled substance offenses. This is identical to the law we proposed the last go-round. In every respect, except the proposed legislative findings have been modified to make it clear that it deals only with drug offenses, and the definition of crime in Section 2, Subdivision 5 has been narrowed to make that clear. Otherwise, it's identical to the law that we proposed the last time.
How much drugs does it take to make a misdemeanor? Say, for instance, marijuana.
Marijuana is not included. Marijuana is not included.
It's excluded here?
It's excluded.
Even if you have 2 cases full?
Well, that would be a felony, and we would be proceeding under a different set of.
Could you bring that as a misdemeanor also, to use it for forfeiture?
No. This Article 220 of the penal law is strictly controlled substance offenses that by definition does not include marijuana.
Cocaine, heroin, opiates, some prescription pills. What we did was we took out. What I tried to do was reach compromise based on what you said. We took out all misdemeanors, narrowed it strictly down to hardcore drugs. Section 220 of the penal law is heroin, cocaine, morphine, ketamine, PCP, anything that would fall in that category, hardcore drug.
But I asked a question. You spoke to someone that didn't want to include marijuana?
It was brought to our attention when it was on the floor that it was to be narrowed. So we tried to give, what I'm trying to do here is I'm trying to find a common ground that we can work together. If you want to put marijuana back in, then I'll leave that to you. But I'm trying to bring something here that I think
if marijuana is to be put into the law, that can be done with the addition of 3 words.
What are those 3 words?
What 3 words would be in Section 2, Subdivision 5, it would read crime means any misdemeanor defined in Article 220 or Article 221 of the penal law of the state of New York. Those are the 3 words.
But what is it something to be a misdemeanor? My original question was how much marijuana is a misdemeanor?
Well, it would depend. It depends on the weight,
right.
Or if it's a sale. If it's a sale, it's an automatic misdemeanor. Right. If it's a weight, it's a minimal. Chris, what's the
I haven't dealt with these crimes in a long time. I think it's 2 ounces. Up to 2 ounces would qualify as a misdemeanor.
Not a small personal use stuff.
Not a joint or something.
Yeah. Right.
Unless you sold it.
So selling is automatic,
yes.
Even if it's small.
Yes.
Chris, you have a question?
Yeah, just to refresh my memory, if we pass this law, it will allow you also to collect for the felonies. Is that correct? This is going to take the state out of the equation
for drug offenses. For drug offenses,
but for felonies, all
yeah.
felonies.
Yeah. We can add in a misdemeanor and take it and bring it back to the county.
Okay.
Whether it be for hard drugs or marijuana.
Well, that's assuming we can legitimately have a marijuana. Assuming you add marijuana, that's assuming we have an appropriate misdemeanor that we can add on to that case. If we have a felony drunk driving case, for example, but there's no drugs involved, we would not be able to cut the state out in that situation. We would not have an appropriate misdemeanor drug offense to charge.
I see. Oh, okay. Oh, all right. So, but the law that you have proposed, it seemed like just about, because you were going to be able to basically assign a misdemeanor to any felony, basically.
The other law was broader, would permit us to seek forfeiture on any misdemeanor, which would mean that in other types of cases beyond drug cases, more misdemeanors would be appropriate charges in those cases. That's not the case with this.
Okay. The other, I think, big thing we had a discussion in our office was about the action that you might take against people who are not directly related with the crime or forfeiture of their property, and then you go through your investigation, and they end up not being charged with anything, the difficulty or ease with which they could get their property back. You understand what I'm saying? We were worried about that.
If the property was initially taken, property can be taken as evidence in a case. Like, let's just use this example. You're driving down the road, and hypothetically speaking, you have a kilo of cocaine in your car. We stop you, and it's found in your car. At that point in time, the cocaine is evidence. If you had a phone and you made phone calls, your phone is evidence. The money in your pocket could be evidence. Even the clothes you're wearing could be evidence. The car could be evidence, and other items in the car could be evidence if they demonstrated that you came or went to a particular place. All of that can be taken as evidence. That is automatically held during the pendency of the case in any case, regardless of whether it's drugs, DWI, any criminal case. Stuff can be held as evidence. What happens with the forfeiture law is if and when you're found guilty, okay, either by a judge or by the trial court, or you plead guilty, at that point we have the ability to seize whatever. If you're found guilty by court, it would be a separate action, civil action brought by us. It would be adjudicated in a court. If you plead guilty, you would negotiate, generally speaking, and as Mr. Ravens said, whatever we would agree to. We would say, okay, you have a kilo in the car, and we may take your car and take that physically, or we may say, give us the fair market value of that, and you may pay us the fair market value of that, and that would be the forfeiture. But the only time you lose your property for good is if and when you're found guilty, or if and when you plead guilty and you consent to the agreement, you settle it.
Which sounds very fair. Just to reassure me, in the opposite sense, not knowing how your office functions really thoroughly, if somebody is not found guilty, is there the habit, the process of getting them back there?
The first function of the district attorney is to exonerate anybody that's innocent. Sometimes exonerating somebody that's innocent can take a period of time. But most of the time, if the law that you have in front of you, drug cases, they're not going to be, while they can be complex, the conspiracies, the movements of the drugs. With most drug cases, you're going to know relatively quickly who's involved and who's not, based upon the items that you find in the car. Based upon today's thing, everyone here has a smartphone. That provides 99% of the evidence in most of the cases to show that somebody is involved in something.
Okay. Personally, I thank you for doing this. I like this the way it is. I have no problem with this.
What I tried to do is I tried to listen to what was said, and I said to them, let's work it down and work together and find something that's working.
And there's no, this is it, next year, if things are working and we feel everybody's getting a fair shake, no reason not to bring back other parts of it and go with it there.
I have no problem with that. I would like to say one thing, that normally I would only give this to your committee chair, but it's law enforcement sensitive, but it is unclassified. I just want to tell you something, and I'll pass it around. I'm going to ask for it back. But it indicates that between June 1st of this year and July 31st of this year, and this intelligence is gathered in the state of New York, of the counties listed, the upstate counties, and even some of the city counties, Orange County had 39 documented cases involving heroin, involving heroin trafficking or the use of heroin, particularly trafficking. It's number 2 in the state, and I will pass that along, just so you understand the dilemma that we face providing prosecutorial services with the police face, because most people either refuse or don't want to hear how bad this epidemic really is. And I'll just pass this along. If you'd like to, I'm a little remiss, I'm not going to give a copy of it, but I assure you that if you want to come to my office and see collections of them, this is just the most recent. I think it's fair to allow you to at least look at it.
We're number 2 in the state. Where's New York State in the country?
Where's New York in the country? I can't answer that, but it's bad. I can tell you. Well, Massachusetts declared a medical emergency.
they have any questions on this?
I just had a comment. I agree with what Chris said. You know, I was actually coming with the mindset, I didn't know that we weren't going to discuss the original law, to be honest with you. I thought we were going to discuss it again, so to come back. And I was going to make the recommendation that maybe we consider passing the original law with a sunset clause, you know, as it was with the DWI. But I want to say it's the comfort of the legislature, the majority of the legislators, to do it this way, what you brought us today. I will support it. I would have supported this tonight, just so you know. But if Chris is saying, I agree with what Chris is saying, if we're going to pass this, what's before us, I would hope that when it's successful, because I think it will be successful, that you do come back to other parts and we build it back up, because I like to see this built up.
I personally, as a district attorney, the greatest chance of anyone in this room being a victim is being a victim of drunk driving.
Exactly.
And I can't stress that enough, but at the same time, I appreciate the fact that you have constituents. I appreciate the fact that there's other concerns. And in doing so, I felt that this was a good compromise so that as a legislative body, you can, I want something passed, because I think if we come back in 14 or 18 months, you'll see that this works and it's not being, you know, administered in a bad way. And it serves public safety. I mean, clearly every police chief in Orange County was 100% behind a much larger version, but I think that this is a good start. And as far as I'm concerned, it's a better start trying to work based upon what I heard in those committee meetings.
What's the committee's pleasure about adding Article 221?
That's what I was just gonna say.
I would be in favor of it.
Yeah,
I thought it was going to include that.
I would make that as a motion from that.
Dennis will make that motion to add those three words, or Article 221, to line 5, definition of crime. Is that correct?
To subdivision 5, definition of a crime.
You have that in there? Melissa seconds that. So why don't we vote on it unless you have a comment?
Just to clarify, which means that adding marijuana as a misdemeanor.
Yes, yes. Well, it says,
Which
the way
would
it
be
reads,
sale or a large quantity possession.
well, in scheme of things, relatively small quantities of possession. We're not talking pounds worth, but up to 2 ounces of marijuana is a Class A misdemeanor, which is the highest level of misdemeanor, or sale, or any sale of misdemeanor would qualify there. These would be misdemeanors as well, because the way it's written, crime means any misdemeanor defined in Article 220, or as you're saying, or 221.
So if you just get caught with a joint, it's excluded. If, you know, if it's used by, you know, obviously your first
Still within your discretion.
Yeah, but
Well,
generally, one joint is going to be unlawful possession of marijuana, which is not a misdemeanor.
That's understandable. But even if it's a misdemeanor, you still have the discretion to say,
Sure.
It's a violation?
Very small amounts, less than, again, I don't know the numbers off the top of my head, less than a half an ounce or something, are not crimes. So they would not qualify as misdemeanors.
To be honest, we don't, in the grand scheme of 22,000 cases we handle, we don't handle a lot of small marijuana cases. Normally, it's over a pound, over 10 pounds is where we find a lot of it.
But again, as we've said, putting marijuana in here would allow us to use this law for forfeiture in larger felony marijuana cases.
sounds like you got all of us on that, so unless anybody has a question, we'll call the question on the amendment to add or Article 220. But then you just explained it a little bit. Well, it's a misdemeanor. You said a misdemeanor is up to 2 ounces.
There's different classes of misdemeanors. Class A
Any class of misdemeanor would allow you.
Half an ounce.
Yes.
and there are only two. There are only two classes. There's an A and a B misdemeanor. That's all there are. One is more than, again, I'm remembering correctly, one is more than half an ounce, one is, one is up to half an ounce, that's not right. One is more than half an ounce, one is more than 2 ounces of marijuana, would be the Class B versus the Class A misdemeanor.
They both qualify. All right, can we call the question on this? To add the words or Article 221 to line 5. All in favor? Aye. Opposed? So carried unanimous. Are we ready to vote on the entire law, or does somebody else? Okay, want to do a roll call on this entire law as it's written in front of us with the amendment?
Bonacic?
Yes.
DiSalvo?
Yes.
Eachus?
Yes.
Duke?
Yes.
Simmons?
Yes.
Vero?
Yes.
Hines?
Yes. All right.
Thank you.
Don't go too far, Dave's not going too far.
Just switch the seats, just playing musical chairs.
Page 87, you're gonna find the budget and the motion to discuss the VA budget, 97 to 95. Want to tell us the highlights of your budget and then we'll go into the questions?
Yeah, I think if you, just give me 3 minutes, I think I got to outline a little bit about what we do. What we do in the DA's office, we prosecute cases in 72 different courts in Orange County. Local courts, town, village, county, supreme, as well as federal courts. 37 of the courts that we prosecute in meet at night after 6 p.m. We serve 36 police departments and 20 federal agencies. We have a staff of 72. All the ADAs, 42 of them, are management exempt. We have 11 investigators. They're all CSCA. But 2 of them are management exempt. So 2 of them are in the union, but they're still management exempt. We have 19 support staff, all CSCA. We handle 22,000 cases a year based upon our numbers with 42 assistants that ranges between 523 and 578 cases per ADA. Just a couple quick things that affect our budget. Obviously, you're aware narcotics have increased sharply. Drug sales indictments in Orange County where people are arrested with a felony have increased 179%. That's where somebody sells drugs. The total amount of drug filings in Orange County just this year up 67%. Just this year, we have seized more heroin in total weight than we seized in the last 5 years combined. This year, we have the single largest seizure in the history of Orange County. What is causing the trend? Some of it is our proactive approach with law enforcement in attacking the problem. But interestingly enough, 60% of all crimes committed in Orange County have some nexus to narcotics. Someone is addicted, someone is involved in a narcotics trade, or they're high when they commit the crime. The second thing that's affecting our office budget-wise, welfare fraud and white-collar crime. It's expected this year that we will prosecute in excess of $600,000 worth of overpayments. So what that means is that $600,000 that left the county coffers were fraudulently obtained by people. We expect to recover at least $60,000 of that in cash payments, which places us near the top of the state in recovery. Since we started our welfare fraud initiative, I want to note we've recovered $93,000 in cash payments from 15 individuals who, when they were notified they were being investigated, came forward and paid back the money that they received completely to avoid prosecution as a direct result of our sweep. Finally, the third thing that drives our office is in public safety, DWI. It is the #1 chance that someone has a victim who fears being struck by a drunk driver. We focus heavily on these cases in the local courts for the most severe financial penalties for first offenders, and with probation and jail for repeat offenders with high BACs. Finally, one interesting thing that drives the DA's office, which often does not appear in the budget, grants. Grants in law enforcement come at different times of the year. We have increased this year. In 2013, the office had $207,000 in grants. This year, we expect $485,000, which we've received, 2 of which you just voted today, which is over 100% increase. One of which will come before you sometime in the near future. In addition to the CART and the Eddie Byrne grant, there's a $75,000 grant for domestic violence, which we'll be voting on sometime in the near future. Moving to the budget. We have presented a budget here that shows a total decrease of 3.45%. I was asked early on to prepare a budget